Hello, everybody. Just a quick review of what we did yesterday. We talked about the federal court judicial system, and so today we are going to be moving on to the North Carolina judicial system. But just a quick review. Remember, we talked yesterday about the court system being an acronym of SAD, meaning Supreme, Appellate, and District. We also briefly mentioned that there are 6 different types of special courts. Each one of these levels of courts is the path that a court case will take on the federal level, starting from the bottom, moving upwards. Remember, if you are convicted guilty, is the only time that you will move upwards. If you're found not guilty, you probably should not appeal that verdict to a higher court unless you really, really, really just want to go to jail. So moving on today we're going to talk about North Carolina court system. And in the North Carolina Constitution, Article 4, it says that justices of the Supreme Court, judges of the Court of Appeals, and regular judges of the Superior Court shall be elected by the qualified voters and shall hold office for terms of 8 years and until their successors are elected and qualified. Justices of the Supreme Court and judges of the Court of Appeal shall be elected by qualified voters of the state. The Supreme Court shall consist of a Chief Justice and 6 Associate Justices, but the General Assembly may increase the number of Associate Justices to not more than 8. So I just read the excerpt to you. Let's go ahead and jump into the questions. It says, who elects NC judges? Obviously, if you go back here, it's qualified voters, meaning you got to be 18. You cannot be serving a sentence for a felony, and you must be registered to vote. Your term length for judges is 8 years, but they can run as many times as they want. And how many people are on the North Carolina Supreme Court? Well, in this article, it establishes that there is 1 Chief Justice and 6 Associate Justices, but the General Assembly can raise the number to no more than 8 Associate Justices. And we'll go on a little while later and talk about who is actually in the North Carolina Supreme Court. So very similar to the federal judicial court, or the federal court system. This is a cake if you look, but this is the SASD cake, SASD, because the lower courts of North Carolina are divided into 2 different levels, and we'll talk more about those in just a second. The district court has original jurisdiction for misdemeanors and civil suits for less than $10,000, and the judge decides guilty or innocent / not guilty on all issues and sentences. But if you recall, there is no jury in a North Carolina district court. The judge decides everything. And this would be like a court you could think about is like a Judge Judy type situation, even though Judge Judy is not actually a judge. She is an arbitrator, which we'll talk about later. But that is the type of court you could think about when thinking about district court. This is when people sue each other. Maybe there's a child support hearing, something like that. Those are examples of cases that would go to district court. But if you move up the line to Superior Court has original jurisdiction for felonies and civil cases that involve more than $10,000. So, like, let's say I let somebody borrow my car, and my car is valued at more than $10,000, and they wreck it, and the damages amount to more than $10,000, and they decide they don't want to pay for it. I could sue them and have a jury in that case. So if you remember, the 7th Amendment guarantees the right to a jury in a civil case, and that's where this comes in. But just like in a federal court case, the jury decides guilty or not guilty, and the judge would issue a sentence. If someone were found guilty, you could move right on up the line to the Court of Appeals. Very, very similar to federal court. That court has appellate jurisdiction, meaning a case will never, ever, ever start on the appellate court. Again, there are 3 judges to make the decisions to keep, remand, or overturn the decision. If a a appeals court decides to keep the decision of guilty, then you could appeal one more time to the North Carolina Supreme Court, and they would have final jurisdiction on North Carolina issues. Very similar to the Supreme Court of the United States. There is one Chief Justice. However, there are only 6 Associate Justices, just as listed in Article 4 of the North Carolina Constitution. And just as we talked about earlier, judges are elected for 8 years, but they have no term limits, meaning they can run as many times as they want. A little different than the Supreme Court of the United States. The North Carolina Supreme Court only has appellate jurisdiction. There is no need for them to have original jurisdiction in any situation. So they only hear cases when there is a North Carolina Constitution issue. Here is our current North Carolina Supreme Court. I'm not going to say very much about them. We're just going to move right on past. So here is, if you're following along, if you've happened to have printed out the note sheet, this is the Venn diagram to compare the 2 different courts. I would say probably 90% of all cases start in state court, and they hear issues with state issues. But if you think about it, most crimes are state issues. Things like speeding tickets, drug charges, things of that nature. Misdemeanors are all state crimes, and so that is why most court cases are heard in state court. Federal court here, a tremendous amount less cases because they only deal with federal issues. So review, what is jurisdiction? Jurisdiction is when you have the authority to rule over an area or make decisions in a specific area. Concurrent, if you go back a couple units, concurrent means both, like concurrent powers that the federal and state government shares. Today we're going to talk about exclusive and concurrent jurisdiction. So we'll move back. Jurisdiction is the authority to give orders in a certain area. Exclusive jurisdiction means that the case can only start at the state or the federal level. So it means you have only broken a state law or you have only broken a federal law. You have not ventured over. So if you only break a state law, then it doesn't make sense that the federal court could try you. So you would only be tried in state court. Whereas if you break a law in the state that also violates a federal law, that is when concurrent jurisdiction would come into play, because cases can start at either the state or federal level, meaning you've broken a state law and a federal law, so they can the 2 different courts can both have the jurisdiction to try you. And that is all I've got for you today, guys. I hope you got something out of this, and I'm really looking forward to seeing all of you.